Lawyers of Reddit, what's your best most badass I rest my case moment? When I was in law school, I had to argue a case for an exam. I was the last in my class to go, so there wasn't anyone arguing against me. I opened with a motion to dismiss since opposing had failed to show. The judge grading me chuckled and said to shake counsel. I still had to go forward, but we got off on the right foot and I ended up with an genius. Not a case winning moment, but a motion winning one for sure. Think of cases like a big conflict, with motion hearings as little conflicts. Opposing attorney was insisting that ruler meant they could do X. I tried multiple times to point out ruler literally did not say that. During the hearing, the judge reached behind them, grabbed their rules of civil procedure, basically a dictionary of rules, placed it in front of the other attorney, and said, show me where rule says X. Other attorney did not take the hint, read rules out loud for a brutal 5 minutes, and gave the book back. I said, Judge, I have nothing to add. It was pretty fun. Oh, that had to be excruciating for everyone, especially the court reporter. Opposing counsel decided that I had coached my witness and gave him lines to repeat that he was lying. Short version is that he asked the witness if he spoke to me before he testified. Witness said he had. Attorney looked like he thought he had me. Attorney asked the witness what I told him, what instructions I gave him. Witness looked him dead in the eye and said, first thing he told me was to tell the truth no matter what. He said the lawyer is never the one who goes to jail, that he isn't going to jail for me, and if I lie, I'm on my own. Attorney looked like someone took the air out of him. Everyone in the courtroom simultaneously looked at me. Only time I've smirked or laughed in court. I wanted to put my feet up on the table, like I was Vincent LaGuardia Gambini, hands behind my head, and say, I'm done with this guy. I had a trial against a guy who was self-representing, and he was constantly asking my client about conversations she had with me. First of all, no, I'm not coaching her to lie, and second of all, there's a thing called privilege, which means the things we discuss are not compatible. It was an exhausting trial. Needless to say, he was ordered to pay about $1 million more than he actually owed. I was prosecuting some kid. He had an antisocial behavior order, which meant that he was not supposed to go to a certain street. He had pleaded not guilty on the basis that he had not been there. I opened my cross-examination by holding up a map and pointing at the street. I said to him, you went here, didn't you? He said yes. In England, we don't say I rest my case. Instead, I looked up at the bench, said no further questions, and sat down. It might not seem badass, but I got the defendant to admit the offense with one question. That never happens. Corporate lawyer, so I don't have cases to rest. But once opposing counsel was forcefully insisting that it was ridiculous for me to expect a certain provision in a contract we were negotiating, and I pointed out that this provision was standard in his own firm's contract forms, as I knew from several prior transactions I'd worked on across from them. Pretty exciting stuff. He took it in stride and said, jokingly, well, of course it's fine when we ask for it. Why do you have the right to do that? We will never do that. Then why do you have the right to do that? It doesn't matter, we will never do that. Then why do you have the right to do that? And so on and so forth. Transaction law is the best. Guy in a divorce case transferred money to the Equity Preservation Corporation. I looked at the corporate filing. There were only 2 shareholders. Knowing who they were, I asked on cross-examination. He denied knowing them. I then asked about them by name. He admitted they were his parents. Was the Bank of Mom and Dad the old name for this corporation? What is the conversion rate between good boy points and American dollars? Currently the exchange rate is 27.1 to 1 chicken tendy, honey mussy not included. I represented a company that was sued for breach of contract by a former independent contractor. Dude basically alleged that my client wasn't paying him correctly in accordance with the contract. During his deposition, Dude admits that he never reviewed any documents to make sure his allegations were true, never reviewed his complaint before filing it to make sure the allegations in it were true, and had no idea whether or not my client actually failed to pay him in accordance with the contract. Basically, he tells me that he was suing my client because he didn't think their agreement was fair, even though he agreed to the terms when he signed the contract. The kicker is that he admitted that he owed my client money. At arbitration, he tries to flip his story and starts giving testimony that is the exact opposite of his dep. So I whip out his transcript and undermine his testimony bit by bit. Needless to say, I won that case. Username checks out. Pretty satisfying story too. Defendant in a bench trial for a speeding ticket said he couldn't possibly go as fast as the officer clocked him. He knew this because he videotaped himself accelerating from a full stop to the location of where the officer sat. His experiment showed his vehicle could only get to 55 miles per hour and not the 67 miles per hour he was clocked at. The adder then moved to have another speeding ticket issued because the actual posted speed limit was 50 miles per hour. 5 miles per hour over is probably just a fine and a few points. 17 over is possibly reckless driving depending on the officer's discretion. I'd take that. But I was in traffic court one time and saw a lawyer straight up destroy a cop with words. The cop had previously testified that the weather on the night of the traffic stop was heavy rain and winds so strong that the defendant could only open his window 3 inches and that the car had stopped on an area with very little shoulder, forcing the cop to approach from the passenger side, not the driver side. The cop had then testified that he smelled a strong smell of alcohol on the defendant's breath. When the defense lawyer got up, he repeated what the cop had said almost verbatim and asked how he could have possibly smelled alcohol on the breath of someone on the other side of the car through a 3-inch crack in the window on a night with pouring rain and strong winds. The cop sort of opened and shut his mouth a few times, squirmed around in his seat, and said, "That's just what I always write in my log to remind me that it was a DUI stop." The judge threw the case out. No motion to dismiss needed. Then he took a break and called the traffic prosecutor and the cop into his office. I'm guessing it wasn't for a nice spot of tea and some scones. Complaining witness accused my client of harassment/stalking. Said she told him numerous times that she wanted nothing to do with him. My client claimed they were dating, but whenever she got mad at him, she'd call the police and say he was harassing her. On the stand, she testified that she'd never dated him, never invited him into her home, wanted nothing to do with him. She presented a photo on her phone of him sitting on her porch to prove that he had come to her property. I asked the judge permission to look at the photos before and after the porch photo for context. Girl had dozens of photos of the guy who was clearly her boyfriend. I showed her one such picture. This is Mr. So-and-so, right? Yes. In this photo, he's on a bed? Yes. The bed is yours? Yes. The bed is in your bedroom? Yes. You took this photo of him? Yes. He's smiling in the photo? Yes. And in this photo, he's wearing your brassiere? Yes. No further questions, Your Honor. I'm relatively junior, so I'm hoping to beat this one day. I defend professionals and brought a motion to dismiss a case on the basis that the plaintiff could not prove my client was negligent as she had not served the required expert evidence. As opposing counsel and I waited for our motion to be heard, we were sitting in the courtroom. The judge, who I did not know and who had not read our materials, wanted to talk to the parties of a short trial which was to be heard after our motion was argued. That matter was also a professional negligence matter and the plaintiffs had no expert support. The judge then spent 10 minutes explaining that he had practiced in professional negligence for many years and was well versed in the evidentiary requirements to prove the element of professional negligence. In fact, he said, I very rarely use the word impossible in this courtroom, but it is impossible for you to be successful without expert evidence. Our matter was then called, and I reveled in explaining to the judge that he was about to hear a motion to dismiss a professional negligence case on the basis that the plaintiff had no expert evidence. I won. My sister got T-boned by a car, causing a concussion when I was younger. Long story short, we were in court with the judge, who asked the driver if he had ever sped before. No, Your Honor, I never speed was his reply. The judge asked him a couple more times If he was sure, if he never sped, ever? The driver was adamant that he never sped and never had before. A few minutes later, my sister's lawyer gave the judge some paperwork. She read it and said to the driver, "It seems that you have some past driving violations. Can you tell me what they are for?" Speeding. The driver had to pay medical bills for my sister.